afternoon, everybody. Today is going to be a little bit of a different format than you're used to. I hope you enjoy it a little bit, but we're going to make you work, as well as us working this afternoon. One of the things that I have long since advocated as we've done these captive programs is that there's just never enough really about the claims and what happens to the claims and how to reserve the claims and what does that effect have on your overall captive. So today we're going to set some reserves. With me today, by the way, I'm Claire Bello-Ogden. I'm with VCM, CCMSI Division, and we are a medical malpractice claims and consulting company, and we have been in business for about 15 years. With me today is Bruce Whitmore and Eileen Shanley. Bruce, you want to say a few words?
Certainly. I am a senior consultant to the Willis Towers Watson captive practice and also serve the healthcare practice as well.
I'm Eileen Shanley, Vice President of Captive Management at Stewart Healthcare. I operate the claims department as well as operations and underwriting, but have spent over 30 years managing cases and setting reserves.
So today, we have an action-packed hour. I'm going to be putting an awful lot of information, and we're going to go pretty quickly through the slides. Our goal today is to get through some overall informational slides in about 15 minutes, and then go through a fact pattern and actually set a reserve for a medical malpractice case. The importance of reserving. We talk about reserving in captives in many different ways, and many different people touch and need that information. The actuaries need the reserving to be consistent and adequate. The excess carriers base reporting triggers on the amount of the indemnity reserves. Auditors look at the reserves for the excess carriers to make sure that the risk has been identified and has been reserved appropriately. And your board looks at the reserves to determine how your program is functioning. Bruce, you want to talk a little bit more?
Well, certainly. What we find is that obviously captives are formed for many different goals and objectives. I have yet to walk into a captive, go through a feasibility study, and find that the goals and objectives don't dramatically change the structure of the captive and ultimately can have an effect on the manner in which the claims are reserved. But I will say this, that in the end, success of the captive will ultimately hinge on premium adequacy, which in turn is driven by the accuracy of the reserves.
And setting reserves also from a financial point of view, if you set your reserves adequately, it allows for profit to be made from your captive and also allows for dividends to be paid if that's the goal of your captive. So claims and reserving is probably the most important part of your captive because it's basically the core of your financial success or lack of thereof.
You know, we even saw this outside of a captive, but this was a client who had a large self-insured retention. And, you know, a prior risk manager had a habit of setting tabular reserves.
Right.
A new risk manager came in, started reviewing those numbers and said, oh my, this is way, way under reserved. So what did that end up doing? Now, that claims manager is resetting new reserves, which in turn is making the actuarial look absolutely insane, right? Because the actuary is responding to the changes in the reserves. In turn, the excess carrier is becoming, whacked out concerned because what do you mean these 8 claims that we never knew about now are being reserved way above, the touch point, if you will. And that in turn, this particular entity had private equity money. So now it's throwing off the financials of the PE firm, who in turn turns around and fires the CEO and CFO. This is how, really these reserves, whether it's a captive or not, are absolutely critical.
And I think that highlights really well what the difference in people can make. And that's goes to the whole title of today is, reserving is part art and part science. Well, the art part can be, personality driven. Eileen can talk to that for just a minute.
Well, as Bruce just mentioned, when I started at our captive, we had had the same captive manager for 20-something years. He had somewhat of a quirky way of reserving things. He would reserve potential claims at full exposure. So when I came in, made some adjustments to the reserves, changed the way we reserved potential events. And as Bruce mentioned, changed the actuarial report, considerably. So we had to sit down and actually talk through what our philosophy was going to be regarding reserving and the types of cases going forward. And as our actuary said, you can do them any way you want to do them, just be consistent about it.
And I think that does require, if you're going to change the manner in which you're reserving, you need to sit down proactively with the actuary so that it's not a surprise.
Right. The worst thing in the world you can do is, and we've seen it happen where we've come in as a successor company too, where we set a reserve and we sit down with the risk team and we sit down with the C-suite and we pull all these things together and we build these beautiful philosophies, and then we do an audit. So the first thing we do is we look at all of the open claims and suits and decide whether or not we would recommend different reserves. Well, sometimes that reserve swing can be like $20 million. And so then you have to, before you change anything, that's when you need to sit down with the actuary and say, okay, do we do this all at once? Do we smooth it in? Do we do it over quarters? But the ultimate adjustment needs to be made. And then from there, we'll be consistent. So it becomes really, really important.
And I think, again, with the risk manager, you also need to make sure that the risk manager, you kind of coach them to protect themselves.
Yes.
Who are going to see those changes upstream, and you better tell them in advance, because none of our bosses like surprises.
Right, nobody likes surprises. And I think, we've talked about this too. You either have a risk manager who wants to pay everybody, or you may have a risk manager who wants to pay nobody. And as soon as you get physicians involved in the practice, you have their individual personalities involved with whether or not things are reserved. Eileen's program reserves PCEs, potential compensatory events. Programs of ours in New York, you open them and you close them and you don't do anything with them. Some have early resolution programs. So all of these will affect how and when you set your reserves. So it sounds pretty simple to say. Reserves are important, so we all know what needs to be paid out of the captive and what will need to be paid as the cases mature over time. I have a rule at our corporate retreats that the first cell phone that rings, the person has to sing a song. But I'll let you off the hook, Eileen. In reality, though, reserving, and more importantly, reserving a program well, is anything but simple. When you combine the responsibility of setting the reserves with insurance line like medical malpractice, which in many, many states has a lightning strike capability or component to the value of the case, it can be a daunting task. Okay? There we go. I always call setting a reserve part art, part science. This is my formula. We take an indemnity reserve equals the total potential damages, which is the science part. These are hard costs. These are things you can look at, touch, feel, understand what the value of the case is going to be driven by some of these factors, times the anticipated percent of liability of the insured. The anticipated percent of liability can be, well, both of these factors can be shifted by what I call soft or the art part of the reserve. And it can be anything from, what kind of witness does our doc make, what jurisdiction are we in, things that will affect a potential value of a case, but it's harder to put your finger on why and how to value that. Eileen essentially gets to the same decision, but her formula is just a little bit different.
So mine might be a little bit more art, while you take into account the special damages, basically is what this case is going to settle for. What's the jury range? And you use whatever information is available in each jurisdiction to determine what that jury range might be. So for instance, if we decide the jury range or settlement range is about 500 to $1 million, if it's an even chance for success, then we would reserve it at 500. If it was a winner, we would reserve half the low. If it was a loser, it would be between the low and the high. And that's basically our formula, and it's been pretty successful. Probably more settlement range now than jury range, so it's a little bit of a hybrid. But basically, what is this case going to settle for with the attorneys in your local jurisdiction?
It doesn't want to change. There it goes. Okay, so we look at the science part, and this is just, I'm going to go through pretty quickly. These are the objective factors, as I said before. Information about the claimant. Is he or she married? Do they have minor children? Were they employed? Are there lost wages? What are the medical bills? Is there future medical care required? What are the allegations made? Are there punitive damage allegations? Are the allegations pure negligence? What's the strengths of the plaintiff's expert? Are there other defendants who we don't insure, which would allow for additional monies from policy limits that are not ours to be available for settlement? Who benefits from any payments? And this tends to come up more from long-term care cases and wrongful death cases where the claimant is gone. And in the long-term care cases, the money's going to a child or a niece or a nephew. If there are minor children in a death case, that's much different because it can go to a trust for college and things like that. But that will affect the value that you may put on the indemnity payment of the case. And our favorite, I see some of our defense attorneys, is there a lien? It's our first question, is there a lien? Do we have Medicare? Do we have Medicaid? Does somebody else have to get paid out of this settlement before the money goes to the claimant? Anything?
Well, I want to touch briefly on the issue of the potentially compensable events. Because
Yes.
one of the things that, we've seen where physicians who will say, hold it a minute, why are you calling this a potentially compensable event? I didn't do anything wrong. And much less then you start to set reserves on them. If they then in turn show up on a loss run, they become very, very, lots of pushback on that. Yet at the same time, if you're just throwing them on the sheet and not paying any attention to the potential value, then I don't think that you're giving a fair value to it.
Yeah, there are so many different philosophies surrounding the potential compensatory events. If you're in a jurisdiction where early resolution and the resolution of a case before it goes to trial, very proactive apology-type programs such as Eileen's, you do reserve the PCEs, you do investigate them as if they're an asserted file. If you're in Florida, they call it an NOI. It's almost like a mini discovery before you either deny the NOI or go to trial. In states like New York, we do nothing. We report the PCE up to the excess carrier and you close it. Because in New York, early resolution is not a thing yet. Pretty much in New York, nothing happens until somebody files a lawsuit. And then if you have a captive that's crossing multiple state lines, within that captive, you may have different ways of dealing with the PCEs. So the PCEs are kind of a sticky wicket. The asserted claims and suits, we know what to do with those. We have to value them, decide what we want to do with them. But the potentials, especially if a physician doesn't want a reserve set on the potential, that really becomes communication and management of the program.
I think the other thing that I would just make passing mention of is that when it comes to setting reserves, you also need to take into account the defense philosophy of the board and or the members of the captive. Certainly, we've seen commercial carriers, for example, who take the position of defend to the death. Others, where it might be a regional hospital, may say, no, we don't want the reputational damage. We want to settle this early and move on. So all of that, in turn, can affect the manner in which you do the reserving.
Which comes to, the art part. Some of what Bruce was just talking about are the soft considerations or the subjective considerations that you have to think through when you're setting an indemnity reserve. Such as the jurisdiction. Is there tort reform? Are there caps on non-economic damages? Who's the judge? Are we in a plaintiff-oriented state like Florida? Even within states where we might be more defense-oriented, you have counties that will stand out as plaintiff counties. Who's the plaintiff's counsel in the case? This seems like a simple concept, but when there are certain plaintiff's lawyers in every single solitary jurisdiction that we know when we see that case, it's a good case. Because it's a good plaintiff's lawyer, they know the medical malpractice, you know they have an expert in their back pocket already, and you look at that case very differently than you do someone you've never seen in the medical malpractice arena. Because there are lots of nuances in how you go about defending and valuing these cases. Is it negligence? Are we the target defendant? Do we own it? Or are we just sort of an ancillary defendant in the case? Are there potential evidentiary issues? Are they looking for punitive damages? Is our defendant likable? Eileen, you can talk to that. That's one of your big factors, right?
I mean, you can't win your case if your defendant can't impress the jury. So that's a big factor, probably one of the most important that actually will skew your reserve high or low, I think.
Yeah.
If they were really likable, like in Massachusetts, it was almost unheard of to sue nurses up until about 5 or 6 years ago. They were so liked by a jury that, and so many people had nurses in their families, that it was almost an immediate bond with that type of defendant. So you almost never saw a lawsuit involving a nurse. You do more now because nurses have taken over so much of the care, especially in a hospital setting. So, so that kind of factor, what's the likability of defendant is huge.
And I always have the last one in that little section there is, does it have an ick factor? That
Or
is
an
like,
oh my God factor.
yeah, or an oh
Right.
my, oh, did we really do this factor? And it may not even be something that's truly below a standard of care or truly negligence, but there's something about the case that just, you know, is going to sit poorly with a jury. I see that a lot in elder cases. I see it a lot in baby cases. There's a sensitivity and an emotional factor that kind of will make a jury go, you know, and those are cases we value very differently.
And it's almost beyond, you know, sometimes we'll do focus groups too, or mock trials to see what that issue. And there might be, say the physician lost their license for a couple of years for substance abuse. How's that going to affect a jury? You know, some of those factors that might not be actual negligence factors, but how are they going to affect a jury in evaluating negligence?
I mean, an ick factor, you know, the nursing home in Florida, in Miami, that failed to evacuate people, and they died, and they were across the street from a hospital, you know, due to overheating from the air conditioning shutting down. You go,
Right.
really?
That's an ick factor, for sure. And you know, it's 11 people died.
Right.
11 people died, and they were right across the street from some place that had water and air conditioning. So those are the things that those values get bumped up. The threat of potential punitive damages, especially in long-term care cases where a lot of this information is a matter of public record, those values get bumped up.
Like when your doctor decides to go to the bank to get drug money during an operation.
Ooh.
Yeah, or they go to dinner. They go to dinner while they're waiting for someone to give birth and don't turn their pagers on and things like that. Those are the ick factors.
Yeah.
And then, Bruce, you want to talk about these last,
You
the
know,
captive-specific
I
factors?
think I actually touched on,
Okay.
in advance, it was, you know, about PCEs and the position, and the position of the board on defending cases.
Okay.
So I jumped the slide.
See, we did it. We got through the slides in 20 minutes. We said 15, but it was 20. So now what I want to do, Beth is going to go back and she's going to connect up and she's going to put up a spreadsheet that is a reserve worksheet that I use within VCM, mostly training my claim staff, but also with clients who are new to the captive industry to get them in the thought process of what it is that we consider. I can tell you, Eileen and I can look at a fact pattern and probably set a value in about 25 seconds. What this spreadsheet is designed to do is take apart that 25-second thought process, because we've been doing this for years, and then break it down so that you can really stop to think through what it is that we're going to do. So I have a fact pattern that's being handed out and a copy of the spreadsheet that's being handed out. While you guys are getting your information, I'm going to walk through the fact pattern with Eileen. And one of the things that we did as we were prepping, which was really kind of cool, is I was giving her the summary as her claims person. Here's a summary of the case. And as my client, she was saying, well, what about this? And what about that? And do we have this? And do we have that? So we're going to try to replicate that and go through the fact pattern. Sure. Okay? Everybody ready? This is a testament to how fast I can shove, how much information can I shove into 55 minutes. Okay, so the case we have today is a breast cancer case. The claimant is deceased. Her name is Margaret Hunter. In February 1st of 2016, Mrs. Hunter, who was then a 40-year-old woman, presented to Acme Hospital ED. She was seen by Dr. Jones complaining of pain and a lump in her right breast. Dr. Jones ordered a mammogram. The mammogram was performed by Dr. Rave, who was the radiologist. The results as they were read by Dr. Rave was that there was no evidence of a tumor and it was a fatty cyst. The claimant was sent home. Dr. Jones did not advise her to follow up with her OB, and she had also not been to her OB since her youngest son, now 6, was born, then 5. So she hadn't been to her OB in 5 years.
Now, quick question. Dr. Rave is independent, right?
Right.
He's
So-
not ours.
Right, so we own the hospital, and we own Dr. Jones, who is our employed physician.
And what's the coverage for the hospital and the coverage for our physician?
The coverage for the hospital is a $3 million primary with a $10 million excess, and our doctor shares those limits.
Okay. And what about Dr. Rave? What's his coverage?
Dr. Rave has an independent policy with a non-insurance, our non-insurance, and he has $1 million and no excess. So essentially, we have $13 million on our side of the house and $1 million on his.
And that other carrier, we can't engage in a coordinated defense.
No, Dr. Rave is very antagonistic. He's throwing our doctor under the bus every 10 seconds.
Okay.
What about our defendant, Dr. Jones?
Our defendant, Dr. Jones, is very, very likable. The pro to him is that he is very good. He was very attentive. The downside to him is he has 3 pending medical malpractice cases.
So no payments against him, just pending?
No payments, just pending.
So what's the likelihood in this jurisdiction of getting that information before the jury?
If he has sworn testimony that has anything to do with a similar type of a process, it might come in. It probably wouldn't come in until there's a payment because it's not a definitive.
It's alleged.
It's alleged,
Yeah.
so, correct. But we would want to look at his deposition testimonies to see what kind of a witness he would make.
Okay.
Dr. Rave is not likable. Dr. Rave does not have any lawsuits against him, so he has a very clean record as a radiologist. But he's very antagonistic in this suit, as you'll see when I talk to you a little bit more about the expert reports.
Has Dr. Jones been deposed in his other suits yet?
I'll have to get back to you on that. This is how it goes. I do not believe so, no. But he
I
has
mean,
been deposed in our
If
suit.
he had been, then we could look at his transcript to see whether that's a factor and how good a witness he'll make.
Right.
Yeah.
So Mrs. Hunter eventually dies.
Right, so she's seen first on February 1st of 2016. They do the mammogram. The radiologist says there's no tumor. We send her home. She comes back 5 months later in August, 6 months later in August. She's now 41 years old. She has further complaints of pain and the lump has enlarged. She's seen by a different ED doc. He's not been named in this lawsuit. A mammogram was performed again, this time with a biopsy, and she was diagnosed with stage 4 cancer. The review of the initial mammogram by a new radiologist showed that Dr. Rave missed the tumor in the first mammogram. In October, 2 months later, Mrs. Hunter dies. So we're looking at a time frame of our knowledge from February of 2016 until October 2nd of 2016, so 8 months, 9 months. The plaintiff's expert says that if we had diagnosed it properly in February, she could have undergone treatment, that she might have survived the cancer, it might not have been terminal, and she would have been able to live at least a longer life than the one she had. She states that our ED doc, Dr. Jones, should have ordered a biopsy, even in light of the finding that it was not a tumor by the radiologist, and states that he should have told her to follow up with her OB upon being released from the ED.
And the plaintiff is married, children?
The plaintiff is married. She has 2 children. She has 2 sons who are now 6 and 8 years old. Her husband is going to make a very sympathetic witness. He has.
Children will testify? The children will testify?
The children will testify. The husband has not yet been deposed. Our defense expert says that there was no way in that 6-month period of time her cancer went from curable to stage 4. At the very least, it would have been stage 3 had it been found the first time, but that the treatment and the result, unfortunately, would have been the same.
And our experts? Do we have experts?
We do have experts, and they're in support of the medicine. The only place they don't totally support our medicine is that they agree that our ED doc, Dr. Jones, probably should have recommended that she follow up with her OB upon discharge from the hospital.
And on causation?
It's a causation defense. They don't believe that the failure to do that fell below the standard of care.
So we have negligence, no causation.
We have negligence, no causation. We have no punitive damages being alleged in this case. We are in Philadelphia County in Pennsylvania. Anybody know about Philadelphia County in Pennsylvania? Oh, yeah. So we thought we'd start with the really bad one, and then we could change some of the factors as we go along through the spreadsheet so we can see what happens to the reserves. The case status, we're still in discovery. We have not gotten a trial date. The plaintiff has not yet been deposed, and we do not have a settlement demand. But from a captive perspective, we need to put a value on this case for a reserve.
So
And
do we-
Dr. Rave has not yet been deposed, right?
Dr. Rave has not yet been deposed.
So we really don't know at this point just how ugly he's going to become.
Correct.
Okay.
Jurisdiction, do we know the judge?
The judge is very pro-plaintiff.
And is it a joint tortfeasor? Is it joint tortfeasor situation?
So is it joint and several liability? Yes, Pennsylvania is joint and several liability.
Okay.
But it's comparative negligence. Now, what that means is, in a jurisdiction where you have comparative negligence, our defendants would have to be shown to be 51% liable in order to be held liable in the action. A contributory negligence or a joint several and joint liability, thank you, would be 1%. And then everybody's on the hook for all of it. So
Did we have a
that
question?
determination makes a big difference in the reserve.
Looks like we had a question.
No, I was just going to be a nerd and ask if you wanted the answers to the
Yes, I do. Because in the, she's cheating on the test already. We are so short in time, what we decided was we would put some of the values in there, but then we're going to pick out 3 or 4 of them that are really hot buttons in the discussion of the reserves and see if we can have a discussion around some of the softer considerations. So this is, yes, sir.
Is the plaintiff contending that the hospital is vicariously liable for the negligence?
Yes.
Of the radiologist?
No,
I mean,
of the ED
Of the
doc,
ED
who we employ.
you really own the ED doc, but how about the radiologist? Is the radiologist an apparent agency of the hospital so that if he is found liable in excess of his limits, are you going to be on the hook as the hospital vicariously on the theory of apparent agency?
Not in this case. In this case, he is a voluntary physician, he's an independent physician, and we don't have that issue in this case. But it's a great question.
Because I'd say in most states, you'd be dead on that. You know, like a radiologist is usually thought of as somebody.
Seen as being part of the hospital, yeah.
Has no way of knowing it's independent and therefore it was vicarious.
Well, and see, here's the soft part, right? Here's the art part already. Whether legally we think we could defend that or not, it's probably something to consider for the reserve, just in case. Because if the jury is charged with it, we'll be stuck with it.
Right.
Okay. So as we go through, I need the spreadsheet. I need a copy of the spreadsheet I can read. Thank you. Okay, so we have some of the hard information going down, her current job. And I guess the first thing we need to do, Eileen, you said this earlier when we were in our prep session, you really kind of have to get a mindset of which side are we going to believe? Are we going to believe the plaintiff's expert, or are we going to believe our expert in terms of where we think we can prove and defend this case? And this is where I, as being a former defense attorney, I can tell you I never met a case I couldn't defend until I couldn't defend it. But that's my job. My job was to be the bulldog. My job was to go out and be the advocate.
And guess what? When I sat, on the captive side, I'm thinking, of course this is defensible.
Right.
And what do I end up doing? I'm guilty, of my own expectations.
And so from the claims perspective, what we like to do is we like to take our defense attorney's valuation of the case from the legal perspective, but then we try to put in some of these soft factors. We try to look at the jurisdiction, we look at the insurance program, and come up with what we think is I hate the word, but an ultimate reserve, because it's never ultimate. So, show of hands, based on the the summary information that you have, do you think that you would give credence to the plaintiff's expert that she could have been cured had she not had the delay in diagnosis? Or do you believe that she probably was too far along in February when she was first seen, and that we're talking about a much more truncated period of time for the reserve? Show of hands for the defense expert. Show of hands for the plaintiff's expert. Oh, this is going to be so much fun. Love it. Okay.
And then watch out for that confirmation bias.
I know, it's going to be it's going to be very interesting. So if we do that, if we look at this reserve let's set from the plaintiff's perspective, that we're in trouble, that we're going to believe the plaintiff's expert. If you look at the lost wages on your spreadsheet, you all have a copy of the spreadsheet because I know the print got pretty small. Small. This one isn't filled in. But the lost wages, if you believe the plaintiff's expert, we have millions of dollars of lost wages if she were able to be cured and live to her full life expectancy of 76.
What did she do for a living?
She is an executive administrative assistant, and she earned about $45,000 a year.
What did her husband do for work? Do we know?
Her husband is, he is an executive. If we believe the plaintiff, we're looking at $2.1 million worth of lost wages. If we believe our expert, we're looking at $115,500. Big difference. So Eileen, from your perspective, when you're looking at this, where do you put a value?
Well, taking into account the negligence issue, taking into account the venue, taking into account the co-defendant, and the finger pointing, probably around $1 million.
Anybody agree? Really? I'm not angry, I'm just disappointed. It's one of my defense attorneys. Anybody disagree? They think it should be more? More. What would you put on it?
I would probably go full limits.
Okay. Susan?
I would probably go around 1.5, between 1.5 and 2, which I think is below the full limits. But I think you get a discount on the causation argument, so that's where I would probably.
Okay, and that's just for the lost wages?
Oh, this is
Just the lost wages? Just the lost wages?
just the lost wages, then
Between the 2.1 million of lost wages and the 115, that's discrepancy,
I would go with the 1 million.
1 million? Million? All right, would you put that in there?
When you were talking about how you're assessing it, the emotive factor of having children involved, that didn't seem to come to a record.
It will later in the, it will
In
later.
1 minute, right next. Very good. You hit me my softball. So the next thing we're looking at is the fact that she has minor children. So what's the value for that, folks? That's a soft factor.
At least $1 million.
$1 million for each child. You can tell you're from New York. What about what about a smaller county? What about Iowa or Idaho or some of the states that aren't so harsh? Would you put the same amount on it?
I'm from Wisconsin, so no,
No. What would you put on it
$500,000.
for the children?
For both.
No.
Okay.
Okay.
So,
I'd say I might do the same thing, but, everybody has their own views, and that's the value of the spreadsheet.
But there are limits in Wisconsin.
Yes, there are. And
Right.
again, that's all very venue-specific, and that falls into this as well.
right. So are there minor children? We'll say yes. Anyone disagree with $750 for that for the moment? Okay. Pain and suffering. She lived for 9 months.
and died arguably, or not arguably, a pretty difficult death.
But Mark, to be mean, we didn't give her the breast cancer, so there would have been some pain and suffering even if we had diagnosed it timely.
See, I agree, I agree with that.
I think it's a low pain and suffering.
Yeah.
I think it's a pecuniary loss case.
I agree with you.
I think it would have probably, I mean, we don't know the factors of the death, but I think it's not a big pain and
Yeah.
suffering case.
The last time I did this session, we put $50,000 on the pain and suffering. It might be a little bit low, but again, remember, this is only one component of the overall reserve concept. Okay, medical bills we know were $150,400, so that's a hard cost that we know. And then we go over to the right-hand side over here.
What are those medical bills?
They were for her chemotherapy, they were for her medical treatment for the 9 months, or the last 2 months that she was alive. She was in hospice and things like that. Will we ultimately pay all of those? No. But that's the difference between building a defense to a case and valuing for reserving purposes. If a jury decides we're on the hook for them, we have to be prepared to have that as part of our loss evaluation. And you'll see at the end that all of this sort of gets discounted by where we think their liability percentages fall. So what we're doing now is just looking at what do we think the total potential damages might be for this case.
I would go back to Eileen's point, we didn't give her the cancer, she was gonna require the treatment anyway. And I would ask also, is there a collateral source rule in
Yeah.
Philadelphia County?
There is, but not till after a verdict is returned. Those numbers would go on the board in Philadelphia.
Yeah, I would ask whether the medical expenses would have been 1 penny less than it had been diagnosed earlier. You know, in fact, it might have been greater.
Absolutely.
You know, it kind of is complementary to the issue of whether she would have lived or not. If she lived, she could have accumulated expenses well in excess of those expenses.
Right. So would you discount that?
I discounted big time. That's not going to be an important
I
part.
would put zeros,
You'd put 0 there?
zero on the specials.
Anyone disagree? All right. Sandy disagrees. You're changing the medical
Medical
bills
expenses to 0.
at 154, that becomes a 0, please.
Because we don't agree that they should be paid.
Oh, that's right.
Consider it reserving. Reserving doesn't mean we're going to pay it, but we want to
Right.
share it.
Agreed.
And it's not something you want to argue before a jury necessarily, so.
Right.
Exactly.
If you're negotiating, you
However
use it.
correct everybody might be, that's not something very
Yeah,
cool.
you use it in negotiation, but not necessarily in front of a jury.
It's for negotiations, right.
Right.
It's not for a jury.
Right. So then the question becomes, when we're sitting here at this point, we don't have a trial date yet, we're still finishing discovery. Are we setting a reserve for settlement purposes, or are we setting an ultimate worst-case scenario reserve? And we'll have to come to that decision sort of at the end of the process. So, okay, so we go to the top of the right-hand side. Here's where we get into who's our plaintiff's attorney. I'm going to tell you it's well-known Philadelphia law firm. I can also tell you that I tend to put a value to that, as you do, Eileen. I don't put a huge value to that necessarily, because the case is the case. You know, the merits of the case is the merits of the case. But when you have an effective plaintiff's attorney, there's a value to the negotiations, and there's a value to how long does the case live? Is this a plaintiff's attorney who's going to drag us into court 27 times a month, trying to get things they're not entitled to? You know, what kind of litigation is this going to be over the course of it? And let's assume that this attorney likes to go to court, motions court, a lot.
Well, in that case, we would need to change this response. Right now, it says not well-known.
Oh, okay. Well, we can change that too. That's the joy of this.
But again, this can all affect the reserves.
Okay, so what value would you put on that?
It's going to increase the defense costs, for
It
sure.
will increase the defense costs. And when you're looking at these reserves, it's not just about the indemnity, it's also about how much is it going to cost us to defend these cases. Eileen?
So for the effect of the plaintiff counsel?
Mm-hmm. He's your worst plaintiff's attorney in Massachusetts.
Lubin and Meyer.
Yes, Lubin and Meyer.
So if it was a Lubin and Meyer case, I would probably put up another 200 on it.
Another 200,000 on that?
No?
Okay. Well, that was 20% of her lost wages. Okay?
So depending upon how you structure this spreadsheet, it could be a percentage multiplier,
Or a
or it
specific
could
amount.
be a dollar amount.
Now, with Philadelphia County, we go anywhere from 1.1 to 1.5 multiplier, depending on who the judge is, how severe the case is, what our defense looks like. So that's the multiplier that I use. And we talked about this too in our prep session of, if you don't know what the multiplier is, like we know it because that's what we do. But if you're handling your claims in-house, how do you learn that? And Bruce, you had some,
Yeah, I
some
mean,
good ideas.
if you're a multi-state, hospital system, for example, you say, what is the source of those multipliers? You might, for example, look up, Medical Protective's filing and see what their territorial multiplier is. And that may be an indicator.
Yep.
And like in Massachusetts, we have what we call the local plaintiff's rag, where they submit all their settlements, all their verdicts, and you can go in and they keep a database where you can go in and sort it by allegation, by injury, and you can see how many verdicts and how many settlements over the last 20 years have been in certain cases, so.
And then
it gives you
finally, I
some
think that if
benchmarking.
if your actuary is nationwide in scope and has lots and lots of data, you can simply ask them.
You can. But I will respectfully say that I'm not sure I always agree with their multipliers.
Fair enough.
I think their multipliers are high because they're trying to set the reserves. I would go to my defense attorneys and say, get a jury verdict summary for this particular type of case because the actuaries are looking at it at a different perspective.
Fair enough. You like this? We all have arguments.
See, we're arguing right in front of all of you.
But that's the value of this.
Okay, so our judges pro plaintiff, do we put a value on that? I don't always put a value on that. I don't always care. But it's something to at least ask and think about.
Well,
I think
in
it-
New
I think-
York City proper, sorry, but in New York City, you won't know usually what judge you're assigned to until,
Right.
after jury selection sometimes.
And very often that's true.
It
So
doesn't even factor in.
this may not factor in until we set a reserve later if we're going to try the case. Okay. The ED doc. We love our Dr. Jones. He's wonderful, but he's got 3 other cases pending against him. But he'll make a really good witness. There's not a NIC factor to him. And if any of those cases become payments, they may or may not be admissible depending on the jurisdiction. So our other verdict jury put $10,000 on that as a value for a reserve. Again, remember, this isn't money we're paying out yet. This is just us trying to put our arms around what all the potential exposure for the reserve might be. Anyone disagree?
What does the National Practitioner Database say about it? So you have asked claims?
No pays. He has only 3 pending.
See, I think how your defendant will testify is probably one of the most, if not the most important factor in evaluating your defensibility and your reserve. Experts somewhat cancel each other out, but it's the defendant's job to take this case across the finish line. And if it's a poor witness, then you're in trouble. If it's a good witness, and I think juries want to trust the defendant until you give them a reason not to. So if your if your defendant is going to make a great witness and can explain the judgment and the decisions he made, or she made, I think that's huge.
I agree.
So would that be a multiplier below 1? Like 9? Almost like a discount that you factor in if you see anything advantage because it happens.
Right, right, exactly.
Influential factor in your subjective part.
You can either do that, or as you'll see at the bottom, and I think we'll start to kind of skip down because I want to make sure that it's almost 10 till we only have a few minutes left. If you go down to the bottom, you can either calculate for it here, or you can calculate for it in what we think this individual insured's anticipated percent of liability will be. Like that percent of liability may go down because they'll make a very good witness. Whereas Dr. Raves may go up because, you know, he missed it, for one. But for two, he's not a very good witness. The facility we have at 10, because we're talking about vicarious liability, whether it's for one physician or two physicians, there are no allegations of nursing problems or any independent negligence issues against the facility. So as you go down, if you scroll down to the bottom there, Beth, as you fill in these values, I have this set to calculate. So our total potential damages is the total on the left plus the total on the right, gives us our total potential damages of what we think this case could be worth. Then for reserving purposes, I take my anticipated percent of liability and I multiply it by the total potential damages. And for each of the different insureds, I set a reserve for their actions, for what I think they may be on the hook for. You can move it up. You know, this is where that, you know, this is more like a guideline. Is that Pirates of the Caribbean? You know, the rules of the pirates, it's more like a guideline. You know, it's more like a guideline, but I think when you lay this out in a process like this, you force yourself to go through all the different criteria and thought processes that could affect the value of the case. And ultimately, if your program says, you know what, we're going to do it in stages over 2 years, because we're not anywhere near finishing discovery, we don't want to put up close to $1 million today, but we'll do half of it now, we'll do half of it 6 months from now. That becomes kind of the art part two of when all of this is going to hit. But this at least gives you a reason when your excess carriers come in and say, why did you set this reserve? Here's why we set this reserve. It was thoughtful. It may not end up being anywhere close. You might get hit for into $5 million, but that doesn't mean this isn't a thoughtful reserve. And I suggest that at every phase of litigation, this is the process to go through with these cases.
So Claire, just in case people can't see, that's 2.8 million, 2,805,000, right?
Right. We have a total potential damages of 1.87 and change. We have our jurisdiction multiplier of 1.5, which brings it to a $2.9 million case. And then we divide that by or we multiply it by the percentage for our insureds. And those would be the recommended reserves that we would put for each of our insureds on that case. Now, the other factor to think about is we're looking at $2.9 million. Our co-defendant only has $1 million. So we may adjust that recommended reserve to recognize the fact that we're the deep pocket. So we may have to adjust that reserve to make sure that we come up to the full value of what we think the case is worth.
Every captive's going to be different.
Yes.
Typical claims that go to the captives, or do you have lower-level claims than the captives?
You have some lower level claims. I mean, some claims they're talking about, stitches that didn't come out and you have a scar, or you have, smaller exposures. But a lot of the medical malpractice exposures can be this large. And, you think about it, this woman lived for 9 months, it was a misdiagnosis. Our expert says she wouldn't, even if we'd found it in February, unfortunately, she wasn't gonna survive no matter what. So you could have a captive put $1 million limit on, or value on this because they believe the defense experts.
Captive would be a relatively small block of chunky claims.
Well, the captive itself, it depends on how the captive is funding. I mean,
Right.
the captive may take $0 to $5 million. The captive might be 3 million X of 1. It all depends on what the parent has set up.
And from a claims perspective, if the captive has reinsurance on the back end, we want to see these as soon as we can so we can report them up to the reinsurers. So they're on notice that there's a potential out there. You don't want to keep suppressing that because then everybody gets surprised at the end and just nothing goes well. Any other questions? Yes, ma'am.
Unless I missed it, I didn't see you take into account that you have co-defendants kind of pointing the finger at each other, at least one pointing the finger at the hospital. That I would put some
Right.
Mine would kind of,
Yeah.
ultimately, I wouldn't put this kind, I'm in Delaware, and I wouldn't put this kind of reserve on my case in Delaware, so it's been accounted for from my perspective, but I didn't see you, I saw the question, but I didn't really see you account for that. So I would.
Right, there is, and I was kind of moving so that we could make sure that we got through all the values. There are two questions of whether or not they'd make a good witness, and that's where I would take into consideration that Dr. Rave is going to be pointing fingers and that he's not going to be a good witness. That also I take into consideration that I think his potential for liability is a higher percentage. Because juries don't like that. They don't like the finger pointing. They don't like the nasty doctor, especially one who missed the tumor the first time. So I do take that into consideration, both in a value, but also in that percentage.
Okay, I think we need to end there, because we're, 4 minutes over time.
Oh, sorry. Any other questions? Thank you so much.